Thank you very much, everyone, for coming out today. And I'd like to thank Mr. Rex Sinkfield for the introduction a little bit earlier. As he pointed out, my name is Dave Roland, and I'm a policy analyst with the Show Me Institute. And today we're going to talk about a subject that is near and dear to my heart, and that is economic liberty and occupational licensing. And as you see, I've subtitled the presentation, "If You Aren't Outraged, You're Not Paying Enough Attention." I can say that because for a long time I wasn't paying enough attention. It took some unique circumstances for me to come to realize this, the role that this issue plays in the lives of so many people across the country, and to come to an appreciation for some of the damage that occupational licensing can do. And that's what we want to talk about today. I'd like to begin by pointing out that it may be an unusual day for some of you, because I don't think that many of you frequently get to enjoy lunch with alleged criminals. But that, in fact, is who you're in the company of today. I'd like to introduce Miss Brooke Gray. She's at the front table over here. Brooke is a horse-tooth floater from, yeah, you can clap, that's great. Brooke is a horse-tooth floater from Holt, Missouri, which is just north of Kansas City. And for years, she has been helping people throughout the state, actually in several states, by keeping their horses' teeth filed down. I don't know if people are familiar, but horses' teeth actually grow throughout their lives. And if you don't get treatment for their teeth, it can cause all sorts of health problems. So Brooke went and got special training to deal with horses' teeth, and she has come back to Missouri, and she's been helping horses in that way for several years. And just a couple of weeks ago, the Missouri Veterinary Medical Board filed a lawsuit against her to shut her down. For anyone who's not familiar, about 20 years ago, the Veterinary Medical Board got a law passed that makes it a criminal offense to essentially lay hands on an animal if you're not a licensed veterinarian. That penalty is up to $1,000 plus up to a year in prison for every animal that you work with. So that is what Brooke is facing. I'd also like to introduce you to Tiffany Lewis and Ryan Grant, if you guys would raise your hands or stand up, either one. They are entrepreneurs from the Kansas City area. They started a website called KansasCityPremierApartments.com that helps people who are unfamiliar with the Kansas City area to find apartments that suit their interests. Very, very clever website that they put together. Their service is just fantastic and very popular. And partly because of that, the Missouri Real Estate Commission took them to court, and unfortunately thus far has been successful in shutting down their business. Now, at the trial, the state admitted that the information that they provide is truthful and that it's completely harmless. The state's own expert witness said, this doesn't require any special training, the information that they're providing. Nonetheless, the court permitted them to be shut down. And so they are currently taking their fight for economic liberty and free speech to the Missouri Supreme Court. And we hope that they'll get their matter heard in the next few months. I would also like to introduce a set of African hair braiders at our back table. We have King and Faye and Anani, if you guys would wave. These folks make a living with the traditional practice of African hair braiding. For those of you who don't know, people of African descent have a different style of hair from Caucasians. And so there are unique cultural practices for hair braiding that have developed over the centuries and have been passed down from generation to generation. Unlike cosmetology, which requires the use of cutting instruments and harsh chemicals on people's hair, African hair braiding involves none of these. It's a completely natural practice. Unfortunately, for a couple of years, the State Board of Cosmetology has insisted that in order to braid hair, you have to get a cosmetology license, which involves 1,500 hours of training. And also the time that it takes to go to school and the expense of going to school. And does anyone want to guess how many hours of training in African hair braiding you get at cosmetology school? Zero. So basically it forces them to get a license in a completely different profession so that they can practice something that they already know how to do. So thank you guys for coming over from St. Louis today. We're proud to have you. I hope that at the end of our conversation that you'll have the chance to meet these people. They are all just spectacular individuals, and I think that the only real crime here is that the state is trying to prevent them from earning an honest living in a harmful profession. But that's what we're going to talk about today. So let's start with just the idea of what is economic liberty. And to get us kicked off, I'm going to start from a personal level. I was raised in a family that had a deep appreciation for the principles of liberty. I was raised to revere the Bill of Rights and all of the freedoms that are protected under it. And so from the time that I was just knee-high to a grasshopper, I was passionate about free speech and the other ideals that are protected in our federal Bill of Rights. I was not as passionate, because I didn't know about it, about the right to earn a living. It's not something that's specifically laid out in our Bill of Rights, but at the same time, if you look at some of the old decisions, both of the English courts dating back into the 1500s, and then especially the early American courts, even before the Republic was founded, you saw courts talking about the importance of the right to earn a living and how this was a fundamental right for British citizens first, and then it was a right that got folded into the pantheon of American rights. And so early on, you'll see American courts talking about the importance of the right to earn a living and how unfortunate it is when the government steps in and blocks people from practicing their chosen profession. And what I came to realize was that this right to earn a living is every bit as important as the freedom of speech and the freedom of religion and these other freedoms that so many of us take for granted. And yet, we're living in a nation where now roughly 1 in 3 American workers has to get permission from the government before they're allowed to go out and earn a living in their chosen profession. So we're going to talk about this a little bit. One of the things I specifically wanted to point out is that the Missouri Constitution goes above and beyond the U.S. Constitution in so many ways. Anyone who's heard my presentation on eminent domain or who heard my presentation on healthcare freedom knows that state constitutions are allowed to afford a greater range of liberty than the federal Constitution does. And Missouri's does that. When Missouri's Constitution was created, they folded in the high ideals of the Declaration of Independence. And so Missouri's Constitution specifically says that there's a natural right to life, liberty, and the pursuit of happiness. And then at one of the later constitutional conventions, Missouri went even a step farther and added to that a natural right to the enjoyment of the gains of your own industry. And that speaks directly to this right to earn a living, this right to use your talents and your skills and provide valuable services to others. So let's talk about the history of occupational licensing. How did we get here? How did we go from a society and a heritage that was so focused on people having this right to go out and offer their skills to one where now so many of us have to get governmental permission before we can do so? Well, it all started back in medieval Europe. Back around the 13th century, you saw the beginning of regulation of doctors. Basically, it would set prices that doctors could charge, and it had some kind of rudimentary barriers to people practicing in a medical profession. Shortly thereafter, you saw throughout Europe craft and professional guilds start to emerge. These were artisans and craftsmen who would kind of band together and say, all right, we're going to make sure that we're earning what we think we need to earn. And if someone's not hiring one of us, we're going to get the government involved. We're going to get the local lord to go and prohibit anyone from working in our profession unless we say that they're up to snuff. And so this kind of really built up in medieval Europe. But as we got into the industrial age and as we got past the age of enlightenment, this kind of restriction on the freedom to work kind of fell out of favor. And so you saw a lot of rolling back of these regulations, especially in England. In England, part of the Magna Carta was devoted to making sure that the king could not intrude on people's right to earn a living in their professions. One of the kind of counterexamples to this, however, is France. If you look at France in the 17th century, they were gripped by this idea that came to be known as mercantilism. It's Ron Calzone's favorite word. But mercantilism was a real phenomenon in European economic thinking of the time. And in France, they actually had strict controls over just about every aspect of industry, including they would send government inspectors around to count the threads in the square inches of textiles that were being produced. Needless to say, France's economic development withered. And if you compare this to, say, the Netherlands or the Dutch Republic, which at the time had nothing like the natural resources of France or England, but it became the foremost economic power in Europe precisely because of the absence of government regulation. So this is kind of the mindset that early Americans came from. They had seen what had happened in Europe. They knew the rights of Englishmen, and they embraced them in their early years. One of the things that really inhibited occupational licensing in the early U.S. was it was seen as incompatible with life on the frontier. On the frontier, every citizen was expected to be their own doctor, their own accountant, their own lawyer. There weren't enough people or enough density of population for people to specialize, really, so it made absolutely no sense to them why anyone would ever put up barriers against performing different types of work. As long as someone was good at what they were doing, they could lend those services out to someone else and assist them in that way. But in the mid-19th century, we saw the founding of the American Medical Association. And the reason that it was created was to encourage states to adopt licensing standards. Now, there had been some rudimentary standards in place before this. This was not a brand new thing. But the American Medical Association kind of became the prototype lobbying organization. They would go to the states and say, you really ought to protect the doctors in this state from competition from what they considered to be charlatans and quacks. And so these laws started to build, and then over time, more and more trade industries, trade and industry associations formed and followed that template to get new laws put into place. So if you look back 120 years ago at the very tail end of the 19th century, only about 3% of the American workforce had to be licensed, and that was doctors, lawyers, and accountants. Just about any other trade, as long as you were skilled at what you were doing and someone wanted to hire you, there was no barrier to plying your trade. But as I mentioned today, roughly 1 in 3 of Americans have to get a license from the government. So there are actually 3 different levels of governmental intervention in the right to earn a living. And I wanted to talk about them a little bit kind of at the outset so that you guys understand what our options are as far as regulating professions. The first is simple registration. If you have a registration scheme in place, it makes sure that the state knows who is practicing what, and so they're able to provide simple oversight of an industry and maybe even prescribe certain guidelines, but they're not enforceable guidelines. This is the lowest level of regulation that you're likely to see. The next level is certification. And under certification, the government establishes certain requirements for training and for experience before you can obtain official recognition from the state and then tell people, I'm certified to do this by the state. But it's not a complete ban on performing a given profession. It allows consumers the opportunity to evaluate for themselves, do I really feel like I need someone who has a certificate from the state, or am I comfortable with this uncertified person providing these services for me? Essentially, it provides a selling point for highly trained practitioners, but it's not an absolute ban. It still allows for economic freedom. And then, of course, is licensure, and this is the most intense intervention that the government puts on the right to earn a living. And not only do they set up, establish standards and training requirements, but they specifically prohibit anyone who hasn't obtained a license from practicing a given profession. And very frequently, that prohibition is backed by the criminal penalties that we talked about earlier. So what are the arguments for licensure? Why would anyone think that this is a good idea to restrict public choice in this way? Well, there are some arguments that we hear frequently. We hear it's necessary to protect people who don't have the necessary information to make wise choices. So they'll say, you know, the law is a complex thing. You can't expect an ordinary citizen to appreciate the difference between a really skilled lawyer and a really bad lawyer. So we have to have licensing so that we make sure that they're only choosing really highly skilled people. That's one of the arguments that is sometimes made. The second one is similar to it, and it's necessary to ensure a basic level of competence in the professions. The third thing is it's necessary to allow for discipline of bad actors. If we have someone who proves to be really bad at this profession, if you've got a licensing scheme, then you can go in and take away that license and they're no longer allowed to offer their services. So these are kind of the standard arguments that you hear. And an underlying current within all of these is the idea that if these license schemes are not put in place, it would threaten the health or safety of the community in some way. That's what's called the police power of the state. Most states, matter of fact, every state I can think of off the top of my head, assumes that the state has the legitimate authority to protect its citizens against threats to their health or safety. And so that's kind of some of the underlying thought about licensure. So the thing is, we can debunk just about every argument that is put up in favor of licensure. One of the things about these licensing schemes is they're usually administered by regulatory boards. And the regulatory boards are made up of members of that profession. Well, on the one hand, people would say, well, that makes sense. You know, you want the people who know this profession the best to be making the decisions. And this was actually very popular in the progressive era. It was known as the rule of experts. And it was held up as the wave of the future, that you would have experts making these decisions so that ordinary citizens didn't have to. And so that's what happens with regulatory boards. The problem being is that members of the profession also have a strong incentive to cater to the other members of that profession, the other people who are already licensed. And so there is incentive in place, not necessarily to protect the consumer, but rather to shut out competition. Because what happens when you shut out competition? When you restrict the supply of something, you drive up the price. And so the fewer practitioners you have, the fewer options consumers have, the more expensive those services are going to be, which is great for the people who are in the industry. Studies have shown that when you introduce a licensing scheme, it typically boosts the profits of that industry by 14 to 18%. Now, why shouldn't that be fine? Isn't it also boosting quality at the same time? Aren't we willing to accept this restriction of entry into the market, this higher price of services, if in fact we're getting a higher quality of service as a result? Well, there's been a lot of research on that. And unfortunately, study after study after study shows there's no increase in quality after you introduce a licensing scheme. Part of it has to do with the way that these laws are approached. The barriers that are put up very rarely have anything to do with how good one is at the actual work of the profession. It usually deals with how good they are at taking tests. And one of the phenomenons that you'll see is that where you introduce a licensing scheme that involves having to pass a test, a whole mini industry will pop up helping people teaching people how to take the tests. So even if you don't necessarily have the skills, you can learn just enough to pass the test, and then you get your license, and it doesn't matter what you know. You have effectively a monopoly on performing this kind of work. The other thing, or one of the other arguments, is that there are already mechanisms in place that will help hold bad service providers to account. The first and the most powerful is simply the power of the marketplace. If someone provides a bad service, word gets around, and eventually people will quit trying to use their services. If someone hears that a nanny has given a bad braid to somebody, or has done a bad job, or was rude, word will get around, and people will quit going to see a nanny to have their hair braided. If people found out that Tiffany and Ryan were giving false information on their website, or if they were misleading people about the apartments that they were talking about, word would get around, and people would quit using their service. So that's the power of the marketplace. That's one way. Another way is we already have an entire legal system that is set up to allow a redress for injury. So if you hire someone to provide a service and they do it poorly, you can sue them, and then they have to pay you for whatever harm they've inflicted. This is part of the reason that we have a system of law. It's part of the reason why it developed. And so being able to tell someone that, well, if you don't do a good job, we're going to take away your license, it's one more thing to tick off a list, but it's not actually going to increase the disincentives as long as we focus on those that are already in place. Another of the counter arguments to licensing is that they have the most harmful effect on the poorest members of society. When it comes to these kinds of services that we're talking about, wealthy people can afford two things. Number one, they can afford to jump over the regulatory barriers to get into these professions, because all of these barriers come along with costs. We talked about with cosmetologists, 1,500 hours of training in a school, and you've got to take a test. It takes a lot of money to be able to devote that kind of time and resources into that kind of training. Well, wealthy people can clear those hurdles without breaking a sweat. For poor people, those are very significant barriers. On the other hand, we talked about how licensing makes these services more expensive. Well, for someone who's got a lot of wealth, it's a relatively small marginal cost, perhaps. So I have to pay $60 instead of $50 to get a massage. It's an annoyance, but I can deal with that. For someone at the lower end of the economic spectrum, that difference of $10 may be the difference between them being able to afford a service and not being able to afford a service. I think this is particularly important when we're talking about legal services. Poor people have a really difficult time affording lawyers. And one of the arguments could be, well, but what kind of lawyers would they be able to get for what they'd be able to pay? It's true that you might not get the same quality lawyer for $30 an hour that you could get for $300 an hour, but some legal representation is better than nothing, I guarantee you. Matter of fact, our braiders can talk about that, about what it's like to try and face a lawsuit from the state when you don't have a lawyer to represent you. It's a huge problem, and it's one that people at the lower end of the socioeconomic spectrum are going to face a lot more significantly than people at the other end. That's an important thing to keep in mind. And then the other point that I think is really useful to make when we're talking about reasons why licensing is a bad idea, licensing tends to kill innovation. There is a wonderful movie that I highly recommend everyone to watch despite the title. It's called Garbage Warrior. It's the story of a hippie architect in New Mexico who came up with a radical idea for how to build houses from post-consumer waste. He wanted to recycle like old tires and beer bottles and aluminum cans and build them into these homes that he would construct. Well, the architects in New Mexico thought he was insane, and they stripped him of his architecture license, even though there was nothing structurally wrong with the houses he was building. In fact, over time, he came to be internationally renowned for these types of houses. He called them earth ships. But he built them in Indonesia after the tsunami. He built them in New Orleans after the floods down there. All at the same time, he couldn't build them in his own home state because they had stripped him of his license. And the movie follows his story as he goes and tries to show the architects and eventually the legislature in New Mexico, you shouldn't be scared of innovation. You shouldn't be scared of new ideas. You may hit upon something that's tremendously beneficial, but unfortunately the regulatory boards, the way that they're set up, the way that they protect the entrenched interests, they discourage innovation. And so that's something that I think is a very important point to make. So the real world outcome of allowing occupational licensing has been that it's run wild. And so just about any trade group you can think of at some point in the last 100 years has stood up and said, please regulate me. I need to be regulated, because they're all going for the additional profits that come along with a regulatory scheme. So as a matter of fact, there has been a regulatory scheme put in place in several cities for tour guides. You have to get a license before you can tell people about the city that you live in. Currently, right now, the law firm in DC that I used to work for, the Institute for Justice, they just, in the last couple of weeks, launched a lawsuit challenging the validity of tour guide regulations in Washington, D.C. There's also interior designers. Now, it's one thing if we're dealing with the actual structure of a building, and some interior designers do that, but the way that the interior design regulations have been written, it would criminalize advising people about the throw pillows that they ought to have in their bedroom. I mean, it's really wide-ranging. What possible justification can you come up with that says that people should have to get permission from the government to give advice about window treatments? And yet, those laws are on the books in a number of states. And the interior designers have been pushing for additional regulations all throughout the country. Casket salespeople. This is another really bizarre issue. In many states, you have to be a licensed funeral director or embalmer to sell what amounts to a box. In Tennessee, there was a reverend of a poor black church who recognized how crazily expensive it was to hold funerals. And he said, for my flock, I want to make sure that they have access to more affordable funerals. And so he started selling caskets wholesale, and the state cracked down on him and tried to shut him down and put him out of business. And that turned into one of the first cases in the last 80 years where a court actually struck down a law that regulated economic activity like that, just because it was so over the top. So one court of appeals, federal court of appeals, found in favor of this reverend, and then over in the 10th Circuit, with a case coming out of Oklahoma, the other Circuit Court of Appeals found the opposite. The wording of the case is actually quite amazing. They actually use the phrase, just as baseball is America's national pastime, handing out special deals or special benefits to chosen industries is the pastime of state legislators. And they were okay with it. They allowed it to go forward, this regulatory scheme, even though they acknowledged it's all about restricting competition. In Louisiana, it was the only state in the nation that required you to have a license from the government to arrange and sell flowers. They actually had someone who would go around department stores, and if they saw an arrangement that had a rose and baby's breath near Mother's Day, they would go to the manager and demand to know which licensed florist arranged those flowers, and if they couldn't tell them, they would take them apart. And they would let them sell the flowers separately from the baby's breath, but you could not sell them together unless you proved that a licensed florist had made that arrangement. And they justified this as protecting the health and safety of the citizens. They won that case. IJ lost that case because the state argued it was important for the health and safety of the citizens. Think about this. This is common. This kind of thing happens all the time. You get these absurd regulations, these absurd restrictions. As you can tell, it's something I'm really passionate about. And the courts uphold it. And what's more, legislatures continue to dole these out. Now, every once in a while, you see pushback. Every once in a while, you see legislators that say, enough is enough. We have to draw a line somewhere. Let's restore some sanity to the process. And so in several other states with African hair braiders, you've seen them exempt braiders entirely from the Board of Cosmetology requirements. They've set up special restrictions that require you to show that you understand basic sanitation. Kansas, for example, allows braiders to practice as long as you take a test showing that you understand the importance of sanitation and how to provide sanitation in your shop, and you post it on the wall. That's all Kansas requires, and then you're free to braid. Other states require a short course, 12 to 30 hours of training in sanitation, but they don't have to get a cosmetology degree. So that's one way that we start seeing a rollback of some of these regulations in other states. And one of the things with the situation that Brooke is facing with horse teeth floaters, we've seen a couple of states now fix their laws. So Oklahoma is the most recent example. Oklahoma had a law very similar to Missouri's, and they made the mistake of actually arresting a Rodeo Star, who, it was a sting operation. They set up a sting operation to bust him floating someone's horse's teeth in I believe it was a Walmart parking lot. And so they arrest him, and they have all these photographs of this Rodeo Star, who's apparently quite attractive, being led away in handcuffs. And the outrage was so great that the legislature went back and fixed this law. But unfortunately, Brooke's not a Rodeo Star. And so one of the things that we're hoping is that the legislature will take a look at this situation and hopefully come to the same conclusion of Oklahoma, although we may not have the star power that they had behind the issue over there. This is a list of occupations that are licensed in Missouri. And believe it or not, Missouri actually has fewer occupations licensed than most other states. Many states have into the hundreds of occupations that are licensed. And a lot of them are little nitpicky things too. But this is Missouri's list. Some of the regulations are more extensive than others, but all of them require the state to come in or require citizens to go and get the state's permission before they practice in one of these fields. You may have seen outside on the table, and if you didn't, I encourage you to grab a copy. My colleague at the Show Me Institute, David Stokes, did a study talking about occupational licensing, and he talked about massage therapy. And he compares Missouri to other states where massage therapy is not licensed. And sure enough, the results showed that while quality doesn't appear to be higher in Missouri than it is in these other states, it sure does make the massages more expensive. And it's a great little study. I encourage everyone to take a look at it and consider it. But one of the things that I really want to press home with this issue of occupational licensing is, particularly in our current economy, one of the hot topics right now for legislatures at the state level and at the federal level is we need to create jobs. And they seem to overlook the fact that with these licensing schemes, they are actively killing jobs. Ryan and Tiffany were employing a handful of people over in Kansas. to help people find apartments. Those jobs are now gone. They're gone. People who were earning a living for themselves and their family, they weren't asking for a handout from anybody. Now they're in the unemployment line. We can create some jobs, lower some of these regulatory barriers. With the hair braiders, again, these are people who are pursuing the American dream. They're using skills that they've been able to cultivate, and they're providing a valuable service, a service that people want to buy. They're earning a living for themselves and their family, and the state is telling them no. Not that there's any harm here, but the law says no. I really think that this is an issue that if people only understood the impact that it has, maybe we could get some traction on this issue. Unfortunately, as I mentioned, I hate to hold up Kansas as an example of anything, but at the same time, Kansas has a lot lower regulatory barriers. When Ryan and Tiffany were setting up their business, Kansas said, "You're free to do what you're doing over here." Initially, Missouri said, "Well, we don't know. It's a gray area." And then they changed their tune. But one of the things that we've talked about is the possibility that maybe Ryan and Tiffany will have to relocate to Kansas. That's jobs and that's tax revenue that will be leaving this state as a result of occupational licensing. And they're not harming anybody. Why would we want to run those people off? Small businesses are the lifeblood of the American economy. And what we have in these occupations, especially the entry-level occupations that don't require a lot of book learning. We put such an emphasis on the idea of formal educational training, but the fact of the matter is that there are a lot of professions that don't necessarily require a lot of book learning. Someone with a low-level education can go out and do a fantastic job, and they can earn an excellent living just by the quality of the services that they provide. And I think that's something that we have to encourage. We have to encourage it. So we talked about these examples a little bit already. This is a picture of part of Tiffany and Ryan's website. As you can see, very nicely done. It allows people to, put in some of the criteria that they're looking for. They can say how many bedrooms they're looking for. They can talk about what part of town they want to be in. They can say, does this place accept pets or does it not accept pets? You can put in all of that information, and then the computer program generates a list of properties that meet your criteria. They also provide, the people that they were employing could provide additional information that's not reducible to this kind of a format. So for example, you know that this building accepts pets, but you don't know if there's a size limit. Well, you could call one of the rental advisors and they could tell you, well, for this building, they accept dogs up to 35 pounds, but beyond that, you're not going to be able to get in. Or they could point out, well, we know that this apartment complex is having a sale this week. And so if you go in and get a lease this week, you might be able to get a lower rent than you could in a couple of weeks. This kind of information is what they were providing. And yet, according to the government, they have to be shut down. I wanted to show the actual, or part of the actual language from the Veterinary Practice Act. I talked about how it was written in such a broad manner that even laying hands on an animal in any manner could be considered a violation. I was not exaggerating. If you look at this, it includes changing any animal's physical or mental condition, including but not limited to the administration of any therapeutic substance or technique on any animal, including but not limited to dentistry, animal psychology, cosmetic surgery, or to render service or recommendations with regard to any of those procedures. As I read this statute, that probably includes dog groomers. I mean, you are altering the condition of the animal in a cosmetic way, especially if you're trimming their nails. I don't see how you get out of reading this law as including pet groomers. And so it's an incredibly broad act. And one of the other things is that the regulatory boards get to decide what this means. Especially when you have ambiguous wording. It's the regulatory boards that decide who gets prosecuted, who doesn't, what does this encompass? What does it not encompass? That was something that we ran into with Tiffany and Ryan, is that it's not really clear what the boundaries of the real estate profession are under the Real Estate Licensing Act. And when we tried to ask the head of the regulatory board, the attorney said the law doesn't permit her to describe the decision-making process. So we asked them questions, well, when the law says this, what did the boards think that it meant? How were they applying the law? What was their thought process? According to the law, we're not allowed to know. It's a black box. But just because we don't know what their decision-making process was doesn't mean that it doesn't have real-world results. In fact, Ryan and Tiffany are dealing with the real-world results of that decision-making process. And then we talked about the cosmetology and the hair braiding situation, and they have, as I mentioned, been actively trying to shut down braiders operating in St. Louis for sure. We believe they've also been trying to shut down braiders in Kansas City. So the question comes up, all right, now that we know all of this, now that hopefully we've stoked some of the fires of outrage about how these laws are being abused, what can we do? And I think we've got some very real possibilities, some very reasonable possibilities, ones that I would hope would not be controversial. Number one is, let's decriminalize it. No one should have to fear for their liberty for providing a service to someone who's happy to have it. Brooke should not be facing a year in prison for every horse that she helps, especially when the owner has asked her, the owner wants her to help this horse. I think that that's completely reasonable to take the criminal elements off the table. Beyond that, one of the things I found when I started looking into this, the Division of Professional Regulation spends hundreds of thousands of dollars a year investigating people like Brooke and Ryan and Tiffany and Anani and King and Faye. They spend hundreds of thousands of dollars a year investigating. And Brooke's not going to say anything today, at least here, but if you talk to her afterwards, or if you get the chance to hear us on the radio this afternoon, we're going to be on the Mike Ferguson show this afternoon, you need to hear about how they investigated her. It's scary, the lengths that they went to investigate her. And so I hope you get the chance to hear that. But we could say, all right, regulatory boards, you're permitted to try and shut down unlicensed practitioners, but only the ones who have received complaints from their customers. As it is right now, typically these investigations take place not because anyone's complained about, not because any customers complained, but because someone else in the industry has complained. So for Ryan and Tiffany, one of Tiffany's former employers, who is a licensed real estate agent, she just didn't like the idea of what they were doing. And so that licensed real estate agent went to the board and said, you need to prosecute these guys. And the board did. With Brooke, it was a licensed veterinarian who saw that she had a lot of clients, and he thought he should have some, if not all, of those clients. And so he went to the veterinary board and pestered them, and they decided to prosecute. None of her clients complained. It was only a competitor trying to block the competition. And then, similarly with a lot of the braiders, it's not that they're receiving complaints about their service. It's typically either pressure from licensed cosmetologists who don't want the competition, or the board sometimes self-initiates proceedings against them. But one of the things that we can do is we can say, all right, no harm, no foul. If you've got an unlicensed practitioner who's actually caused harm to somebody, fine, you can go after them. But if they're not hurting anybody, just leave them alone. Let them do their thing. Let them earn a living. Another option, and as you can see, these are in kind of preceding layers of acceptability to the powers that be. I would love to see a clear right for consumers to make their own decisions about who's going to provide services to them, as long as it's a lawful service. I am not advocating, that we legalize certain, historically questionable or morally questionable professions. But if it's a legal service, if someone can provide this service legally, then why not let consumers choose who they're comfortable with? Particularly when we're talking about horses' teeth. One of my colleagues has remarked that there is no one more passionate in the world than a horse owner. They are going to make sure that they are not putting their animals in the hands of somebody that they're worried about harming them. They're going to do their homework. And for anyone who wants to hire a licensed vet to handle their horse's teeth, they're more than welcome to do it. By all means, if that's what makes you comfortable, that's great. But if someone's also comfortable with someone like Brooke, who has a world of experience and training on this issue, why not let them choose her? And then the last one, which is what I would ultimately love to see, is to convert the existing licensing requirements to certification programs. I think that one of the most important things that we can do is, at least practically speaking, because we're dealing with some very powerful interests. All of these trade associations have lobbying groups in the Capitol, and they will scream bloody murder at the idea of rolling back these licensing restrictions. So, one of the things that I would love to see is, let's leave the standards in place that they've asked for, but convert it to a certification program so that they can go out and they can advertise their qualifications. They can say, I'm state certified, this other person is not, you should be coming to me. But ultimately, it would leave the choice in the hands of the consumer. And I think that ultimately is the most powerful regulation that we've got, the power of the consumer to choose for themselves. So that's going to wrap up my presentation. We've got just a couple of minutes to take some questions. If anyone has them, I would love to answer. Yes, sir. Oh my goodness, the horror. But yes, that's precisely what I mean. Actually, an important point that's been made in some of the literature on this is that it's perfectly legal for universities to go out and hire unlicensed professors if they want to, but you don't have schools going out and hiring a high school graduate to teach, advanced physics. Why? Because they know that person's not trained to do it, not skilled enough to do it. The big scare story that you always hear from proponents of occupational licensing is, well, we don't want just anyone performing brain surgery. Well, how stupid do you think the American public is? Do you think they're going to go and hire a complete unknown to do brain surgery or to do something that important? American consumers have more intelligence than that. If someone is willing to take a risk on an unknown quantity, it might be that they don't have the money to hire someone who is more highly trained. And so perhaps they should be allowed to take their chances in the hopes that they can get a service that otherwise they wouldn't be able to have at all. Again, there are going to be a lot of people who come out of the woodwork to talk about what a terrible idea that is, but I think that it's clear that we trust the American people in some regards. Why not trust them in other regards? Following up on that, I also think that one of the dangers of occupational licensing is it leads to a false sense of security. If you're dealing with a licensing scheme, you assume that anyone who's engaged in this occupation is going to have a certain level of competence, when in fact that is not the case. One of the things again and again that we see in the literature is that the licensing schemes are not particularly effective at weeding out all of the incompetence. There's still plenty of incompetent people who get licenses, but people's shields are down if they assume that someone has achieved a level of competency. If you don't have that licensing scheme in place, they may be more circumspect in evaluating someone's credentials. They may be more inclined to check references and that kind of thing. So, Steve.
You mentioned higher education a moment ago. What about K through 12 in Missouri, both public school teachers and otherwise? Homeschooling is relatively low regulated in Missouri. have a license to teach your own children, but what about in the public schools and otherwise?
I love this question because at one point in DC, I'm also very passionate about education. And at one point, I considered throwing my hat into the educational arena and signing on with the DC public schools. For anyone who doesn't know, DC has the absolute worst public schools in the country and is not even close. They spend more per student than any other jurisdiction, and they are far and away in 51st place in just about every evaluation category. So at one point I was agonizing over this and I thought maybe I could help. And I looked at the requirements. I don't want to brag, but I've got 2 bachelor's degrees, a master's degree, and a law degree. And I could not teach in DC public schools because I hadn't jumped through the appropriate hoops. I would love to see a lowering of the barriers. And Missouri's already taken some steps in that direction. We adopted some alternative teacher certification that provides a little bit different route to getting quality teachers in the classroom. And I think that's a good step. But ultimately, I think it ought to come down to let the schools decide if they think someone is going to be a good teacher or not. And give them the authority that if it turns out they're not a good teacher, you can get rid of them. That's a challenge as of right now. So, yeah, Bruce.
They're going to protect us. Let's get some teeth.
No, I've never heard of any licensed cosmetologist going to jail for a bad haircut. You know, of course, you do see you've seen African hair braiders arrested, not because their services were lacking, but because they were unlicensed. But I'm glad you brought up barbers as well, because it's a fascinating study. We talked about how originally you had doctors, lawyers, and accountants who were licensed. One of the earliest adopters of licensing schemes were barbers.
At least 1929.
Earlier, yeah.
That's the earliest state.
Yeah, Missouri and Illinois both adopted their regulations about the same time in the early 20th century. It was about 1908. And there is a fascinating Missouri Supreme Court case from 1912 that talks about the barber licensing requirements. If you guys are interested, please send me an email. I will forward you a copy of the case because it's really fascinating. They had created apprenticeship requirements, but forbade the teacher or the student to accept any money for haircuts that they gave while the student was training. 2 years, they were not allowed to accept any compensation for the haircuts they were providing. And the Missouri Supreme Court took a look at this, and they were like, this is ridiculous. How in the world can you justify telling someone they're not allowed to accept any compensation for a service they're providing? And the Missouri Supreme Court called them on the carpet, and they said, this law is not about ensuring better barbers, it's about limiting competition. That's all this law is. And they went so far as to say it's un-American to restrict economic liberty in that way. Fantastic case. That unfortunately is no longer the law of the state. Now it's basically if you have a restriction, the courts are waiting there to put their rubber stamp on it. But we're hopeful. One of the things that the Institute for Justice is working to do is to try and push the law back in the other direction. And groups like the Show Me Institute are trying to provide the intellectual firepower for those lawsuits. We want to expose the effects of these licensing laws so that then, hopefully, we can persuade both lawmakers and judges that, look, this is just a terrible idea and it's bad for liberty. Yes, sir.
A couple of points. One is the state blurs the line. Blurs the lines really well between licensing and certification. There's really, in a lot of occupations, very little difference. You still have a piece of paper, you still have CEUs, they can still revoke your privilege. Put a number on it, we can't go to St. Louis, Master Tech Clone. We can't go to St. Louis and practice, even though it's 30% cheaper because of economy of scale to operate in St. Louis. So it's costing, 30%, that's a hard number to be put on it. Additionally, in St. Louis, we can work on the left side of the street, but we can't work on the right side of the street. experience or previous licensing or education unless you have apprenticed under one of their licensees. And so that's right there in Cole County. So you have to get a signature from one of their licensees and have apprenticed under their licensee before you can practice in Cole County. So the real issue is that not only is the state getting involved, but worse than that, the counties and municipalities are doing it in their stead.
That brings up two issues that I want to address. The first is that, you know, be careful when you say I'd like to see something licensed, because you might get your wish. One of the things that has been shown, particularly when it comes to trades, especially the electrician's trades, is that the introduction of a licensing scheme actually makes it more dangerous for citizens, because they can't afford the licensed professionals to come in and do the work, and so they try and do it themselves. And so particularly with electricians, you saw electrocutions go up of citizens because they were trying to do this work themselves. So that's an unintended consequence that can come about in certain professions. But the other one of the professions I didn't talk about is moving services. There's actually a federal lawsuit right now being handled by Pacific Legal Foundation in California, but it's in St. Louis is where the lawsuit is. Missouri law allows potential competitors to put veto power over licensed applicants. So a guy named Michael Muni had a moving company. It's licensed to move stuff between states. It's licensed to move stuff within the city of St. Louis. But when he applied for the license to move stuff in the rest of the state of Missouri, his competitors said, nope, we don't want it, and the state shut him down. So there's, and one of the interesting things about that is it doesn't even allow an ordinary citizen to raise that kind of a question. If an ordinary citizen has had a bad experience with a service provider, they don't get to go to the state and say, we had this bad experience. It's just the potential competitors who get to raise objections. So that federal lawsuit is moving forward. But there are a handful of professions that are licensed locally. In particular, auctioneers is one where the state requires localities to license auctioneers, and there are other professions as well. One of the items out there on the table outside is a paper written by Dave Stokes that talks about the way that HVAC installers in St. Louis County managed to get a monopoly on working in residences. There was no outcry from the consumers about the quality of services being provided, but the established interests in that industry said, well, we're not getting enough work. We need to have a monopoly over residential work, and the county approved it, in spite of Mr. Stokes' excellent testimony. So I believe that we are out. Are we out of time, or do we have time for one more? Okay, one more. So, Mr. Calzone.
Quick comment. I'm glad to hear you using phrases like un-American and monopoly, because this does strike at the very thing that was at the foundation of the founding of our republic. We fought a war over this very thing. It came from during monopolistic privileges. Go back and study about the Navigation Acts. The East India Trading Company was guaranteed that they dumped the Boston Harbor because they had monopolistic privileges and traded tea and other things, guilds and so forth. This strikes at the very core of what America stands for.
Can I just ask you a quick? This is quick.
Sure.
Has any state tackled this in any systematic way?
Not that I'm aware of.
Other
No.
than just these particular claims?
No, as far as no, as far as I know, as far as I know, no state has systematically tried to roll back its licensing schemes. There have been states where there was a push on maybe a broader issue than we're dealing with. So, for example, I talked about how several states have exempted African hair braiders from cosmetology requirements. That's kind of the norm where you see any legislative pushback at all. It's very narrow. It's in the form of a carved-out exemption. There have been broader pushes in, like, to eliminate a licensing board. I can't think of an example off the top of my head, but I know that that's happened. But I can't think of any effort to reconsider on a wholesale basis. Okay, is this really effective? Is this doing what we expected it to do, or is it just creating problems for people within the state? And I would love if Missouri would be the first state to engage in that kind of an evaluation. But in the short term, I'd settle for just some of the more limited options that we discussed.